Well, we made it to Friday. Congratulations, everyone. You did it. I'm here to say thumbs up. But next week's going to be a pretty big week. October 11th, Wednesday, you've got a hearing in the Southern District of Illinois Federal Court expected, where attorney Thomas Magg is going to be presenting his arguments on the vagueness challenge of Illinois' gun and magazine ban. So we're going to take a moment to kind of delve a little bit into how we got to this point. Of course, with Magg, he filed this case on, like a week and a half or 2 weeks after the law went into effect. He was actually the first one to file a lawsuit in state court challenging the gun and magazine ban on a whole host of issues. Second Amendment grounds, 14th Amendment grounds, Fifth Amendment grounds, vagueness grounds. We've talked about a lot of those things. But other lawsuits started to be filed. Magg's case was then transferred from state courts to federal courts. And then you had other cases filed in federal courts in the Southern District. Those cases were then lumped together, challenging the gun and magazine ban on a host of grounds, including the federal firearms licensees of Illinois, really driving home that issue of right to repair, especially focusing on the different parts. But they decided to only hear the Second Amendment challenge in the Southern District, if you recall, earlier this year. And that was down in the Southern District, but while that was going on, you had cases in the Northern District challenging Naperville's gun and magazine ban, challenging Chicago and Cook County's gun and magazine ban, while also those cases in the Northern District, one in particular, was modified to challenge the state's gun and magazine ban as well after the state enacted that. So you had different outcomes. The consolidated cases in the Southern District that included Thomas Magg's case, the Langley case, all consolidated under the auspice of Barnett. So just so we understand, you got consolidated cases in the Southern District as you had consolidated cases in the Northern Districts. Ultimately, all go to the Seventh Circuit Court of Appeals with different outcomes from the different jurisdictions. So we're still waiting on the Seventh Circuit Court of Appeals case to be decided by the appeals court, and whether or not it's going to uphold the law in the face of Second Amendment challenges, or if it's going to review other jurisdictions where they're dealing with this same kind of question out of California, Hawaii, Washington State, and elsewhere throughout the country, Texas. You've got different narrow arguments on Second Amendment law and whether or not certain laws can infringe upon that Second Amendment right. So where we're at now with the Magg case is he has, of course, waiting for the Seventh Circuit Court of Appeals on the Second Amendment grounds. He's bringing up his vagueness issue back in the Southern District because they have yet to really get to the merits of the issue. And this is kind of picking apart each one of these different questions of the merits of the issue. So the Southern District's October 11th, that's Wednesday, they're going to be hearing this case where Magg's going to bring forward the arguments of vagueness. So let's go ahead and take a look at the filing and the docket here for where we got to this point with the Magg case. So if you're watching along, you'll be able to see this. You had, several different docket entries on May 19th. There was a motion for summary partial judgment on the vagueness issue that was filed. That was filed by the plaintiffs, Langley. They offered up a bunch of different exhibits from, descriptions of an AK-47, an AR-7, an AR-30, different types of firearms that they laid out in their different motions. With all of the questions of vagueness, they are using those as exhibits. But then you forward up and you see that on June 2nd, the state actually motioned for a stay on the partial vagueness question. Then on the 5th, you've got the order that the court was in receipt of that stay in the motion, and the Langley plaintiffs shall respond by June 14th. But June 12th, you have the response to that motion, and here's what that motion ultimately lays out when they filed this June 12th, and this is from Thomas Magg. He says, this court's previously heard a consolidated motion for preliminary injunction limited to Second Amendment issues. Plaintiffs in this case agree to temporarily forego briefing and ruling on the non-Second Amendment issues in order to expedite a trial court decision on actual Second Amendment issues, as most of the litigants in the consolidated action brought only those claims, despite other obvious claims that could have been brought. Plaintiffs were crystal clear they are not waiving those Second Amendment issues. This court, at oral argument on the Second Amendment issues in the preliminary injunction, even commented that we will have to get to the non-Second Amendment issues in the future. That future is now. Defendants note in the court's order, and plaintiffs simply note that this is a later date upon which the claims can be litigated. To the extent the court wishes a formal motion or formal requests to litigants those issues at this time, to litigate those issues, the court may consider this response as the same. So the Seventh Circuit Court currently has jurisdiction over interlocutory appeals, and they go through that. But ultimately, they say vagueness and Fifth Amendment issues remain because they've dealt with the Second Amendment issues, but the Fifth Amendment and vagueness issues remain. Every day that goes by, defendants is purporting to enforce this statute to the detriment of the people of the state of Illinois. Justice delayed is, in fact, justice denied. Every day that goes by with challenged statutes in effect, citizens in Illinois risk on a vague and undecipherable statute, or worse, being unable to mount an effective defense if and when attacked for fear of using a firearm or ammunition feeding device possibly potentially prohibited by the act. So they go through discovery, and he spells that out in his filing. He also talks about the piecemeal litigation and lays some other things out, and waiting until the close of discovery to rule. That lays some more arguments out there. In conclusion, ultimately, Mag says the court should give defendants 2 weeks for this date to file opposition to the motion and set oral arguments on the same as the soonest mutually workable date for the parties and the court. So again, that was in June when Mag filed that in response to how we're moving forward here with that case. And then you had Stephen McGlynn file an order here before the court. You've got Brendan Kelly, ISP director. You've got Jeremy Langley with his attorneys regarding the court's granting motion of preliminary injunction. The interlocutory appeal pertains to the Second Amendment claims presented in this case and is currently pending before the Seventh Circuit. The court's consolidated this case with other cases for the purpose of common claims and stayed litigation on other claims presented, although the interlocutory appeal does not pertain to the criminal enforcement of the Protect Illinois Communities Act on vagueness grounds. As the Langley plaintiffs now raise, the appeal is fully briefed and argued and may impact enforcement of the Protect Illinois Communities Act. Thus, in the interest of judicial economy, the motion to stay, in part, consideration for the motion of summary judgment is stayed for 45 days. The court will set a status hearing for this in 45 days. So again, that was on June 29th. And then you look at the dockets, and ultimately we have the latest where they have this this date set. St. Louis. It's going to be October 11th, 1:30 p.m., and it's going to be before Judge Stephen McGlynn. So anticipating that, I've already got it on my calendar. I'll definitely be traveling down there to check that out. So looking forward to hearing those arguments, and we'll definitely be bringing it to you next week. All right, so that's Wednesday, the hearing, and then Thursday morning we'll definitely unpack a lot of what we have done there. But you can, of course, follow along in real time. Just search Bishop on Air. You could do that on X. You could do that on Facebook. You could do that on YouTube. Again, search Bishop on Air. Follow, subscribe, like, do whatever you got to do there, all right? It is Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk.